Thank you for joining us today for the ABA's Civil Rights and Social Justice and Commission on Immigration program. This rapid response project addresses how our civil rights are being impacted by actions taken by the new administration. My name is Homero Lopez Jr., and I am the legal director at ISLA and previously served as an appellate immigration judge. And I'm thrilled to welcome you to this conversation. These videos are a unique opportunity to address what is happening in America today, clarify any misinformation or disinformation being spread, and how civil rights and social justice advocates can act to protect the rights of everyone. Today's topic, the recent Supreme Court decision in Mullin v. Otro Lado regarding the asylum process, is more critical than ever. As we confront a barrage of attacks from the current administration against immigrants, particularly asylum seekers, it's essential to examine how these issues intersect with the principles of justice and equity that guide the work of our section and the ABA more generally. We are honored to have with us Mary Giovagnoli, who is an immigration attorney, policy expert, and author who has worked for almost 30 years in both the federal government and nonprofit advocacy to improve the immigration system and strengthen democratic institutions. She most recently led the Office of the Ombuds for Unaccompanied Children within the Department of Health and Human Services. She is a former executive director of the Refugee Council USA and has held senior roles with Kids in Need of Defense and the American Immigration Council. And also Kevin Gregg, who's a partner at Kurzban, Tetzeli, and Pratt, based in San Diego, and the host of the Immigration Review podcast, something you should follow in order to get your immigration law updates. Their expertise and dedication to immigration law have made them leaders in their fields, and we are grateful for their willingness to share their insights with us. With that, let's get started. Mary, can you give us a summary of the decision in Mullin v. Otro Lado? What did the Supreme Court say?
Thank you so much, and I'm very glad to be here and share my thoughts on this. I should preface it with the fact that I was among the group of former government officials who filed an amicus brief in the case, sort of explaining the process that we went through really to come to these decisions about how to process asylum at the border, which will become relevant as we talk through this decision. But in Mullin v. Otro Lado, the majority of the Supreme Court rejects the principle that's been enshrined in domestic law and international treaty obligations for the U.S., that an individual seeking asylum at the border has to be given a chance to make their claim. This case originally was brought back in 2016 in response to the Trump administration's decision to turn people away at the border who were clearly trying to ask for asylum, something that the administration calls metering. The rest of us mostly call it turning back or turning away. And the issue seemed to have been put to rest by lower court decisions that found the practice illegal. And by the time that had made its way through the appellate court, the Biden administration had come into its own, I guess, and they chose not to pursue the case. But the second Trump administration persuaded the Supreme Court to revive the issue, essentially asking for an advisory opinion on whether this turnback policy was legal. And unfortunately, the court agreed to take the appeal. During the oral argument, what became very clear was that there were two really different perspectives on the case. On the one hand, the respondents and some of the justices were focused on the fact that this practice directly violated asylum law, which provides that anyone within the country or arriving or in the process of arriving in the country at the border had a right to apply for asylum or at a port of entry. The government frequently interfered with that right. During the time when the process was active. They would forbid asylum seekers from entering. They would tell them that there wasn't capacity. There's evidence of people lying to asylum seekers, and sort of just let them go back to wait in Mexico and elsewhere under very, very dangerous conditions that led to very well documented cases of deaths, kidnapping, sexual assault. Every parade of horribles was really happening just on the other side of the border to people who were trying to get to the U.S. to raise an asylum claim. So for the respondents, the case was about the legal and moral obligations to protect people from persecution and holding the government accountable when it interfered with that right. The government, however, argued that there's no right to asylum until someone had physically entered the United States, ignoring an abundance of language in the statutes governing sort of the interplay between admissions, the inspection of people arriving at the border, when the notion of laying out an asylum claim is first heard. And it clearly, when you read all the statutes together, that contemplates a process that begins often before they've reached the physical point of entry, where the claim can actually be made. But there's often encounters before that, and really from the moment there's any kind of encounter with the government, there is the sense that you are kind of in that space where you should be able to raise your claim. But what the government argued instead was that what happened outside the US was immaterial. The majority then adopted the government's interpretation that arriving in requires physically stepping foot across the border. So that if you don't do that, you can't make a claim, even if it's obvious that that's your intention. And at the time of oral argument, it was so disturbing because many of the justices really became fixated on this idea of arriving in, and really started to play around with ideas like, well, if you're knocking at the door of someone's house, you haven't arrived in their house yet. Or if you're waiting in line somewhere, if you're the 91st person waiting in line and the first person isn't getting in, well, then you can't possibly think that you have an opportunity to get in. And what was so disturbing and crazy about it really was that it was this notion of people standing in line in the same way you go to the DMV and you take a number and you wait and you wait and you wait, and it's annoying and frustrating, but eventually you get your chance. Without any sense of the context and real understanding of immigration law, frankly, that was what was happening at the border, what it's like for people when they approach the border, what the usual practice has been in terms of how people come up, they get inspected, a determination is made about whether they have, a valid entrance document, or if they are afraid to return to their country, they might get put into different kinds of processes. But the point is that there's an actual touch, an actual conversation with that person. And that's what the government was eliminating. And the Supreme Court just seemed really, really unwilling to focus on that. Justice Sotomayor dissented with great force about all of this and declares that the reality of the decision would be that more people will die and more people will try to enter unlawfully, because people will come if they're afraid and scared and persecuted. And that just seems to be completely irrelevant to the majority, who really have upended more than 30 years of policy and practice, that back as a baby attorney, I helped to work on and build, that really made sure that even with the new laws that had come into place in 96, we didn't obstruct people's ability to seek asylum. And I think that, this notion of context, which is something that Justice Jackson often talks about, is really, really important in this case. And in her separate dissent, she says, the court is not a law student puzzling through a difficult cold call. When we issue opinions, we create legal rules with real world impact. And in this case, there were no decisions, there was no hard facts, because there wasn't really a policy in place, which allowed the majority to sort of spin out whatever vision of waiting in line they wanted, even though there was no real line. The government didn't try to manage it in any way and really relied on the asylum seekers themselves to try to get into some line. So really, it comes down to the fact that asylum law has been completely reinterpreted without context. And by narrowing the focus on the one word in the statute, the Supreme Court, I think, may have condemned thousands of people to future harm. I'll turn it back to you, Omera.
Yeah. Thank you, Mary, for the great analysis. Kevin, do you have anything to add?
Thank you indeed, Mary. Very well summarized. It's complicated stuff, but some of it is not. Just a few things I think worth noting is, first, practically speaking, what this seems is that, just to be clear, all the legalese, all the what it means to arrive in, Trump administration or a future administration who is not going to do immigration in good faith can put their DHS officers 25 feet on the other side of the Mexico-US border and say, we don't want to let you come and try to apply for asylum. And the Supreme Court has just blessed that. Uh,
Yep.
there was an inspector general's report in this case that indicated that Trump too, they were just lying. There's first of all, there's no such thing as capacity at the border, but even if there is, that wasn't the officers were lying and saying just we're not listening to claims today. What does that incentivize? I do not advise this, but it incentivizes people sneaking into America through the desert because that is then the only way you can apply for asylum based on this decision if an administration is going to be disingenuous. And we know more people will die when they sneak through the very dangerous desert. And additionally, we of course don't want to put into place policies that encourage people to break the law rather than to come to the border and ask for asylum. So lot going on there. Legally speaking, the court relies on the canon against anti-surplusage. I'm not going to get into what that is, but that canon has been relied on heavily by circuit courts to strike down the Board of Immigration Appeals new decision not granting bond hearings for people who enter the United States without inspection. If the court is not doesn't really care about that canon, we're going to have a very scary term next term when the Supreme Court inevitably takes up that issue. And then the final thing, and then I'll stop. And it might be from a dissent. If not, it's from commentators. Asylum law exists. The Refugee Convention, the asylum law that Congress passed, the primary factual story that everyone tells that influenced all of this is the story of the MS St. Louis in 1939, I believe, in which almost 1,000 Jews are on this ship coming to America. And America says, we're not accepting you. You can't, we're not going to let this happen. They turn the ship around and they go back to Germany. And many of those people are ultimately killed in the gas chambers. The United States said never again. Unless I'm missing something, the MS St. Louis can absolutely happen again today after Otro Lado. It's the exact same thing. That ship is not in America. And the Supreme Court has just said that the administration can turn it around. So we are right back where we started 80, 90 years ago when we said never again. And so that should give everybody a lot of pause.
Yeah.
Yeah.
It has stunning implications for the a time when we're celebrating the 75th anniversary of the Refugee Convention, which sort of was the first iteration of this never again philosophy. And I think very well said. Justice Sotomayor talks about it in her dissent, and it's chilling to think that we would we'd turn our back on people in fear of persecution.
Yeah. I mean, thank you both for that analysis and that sobering reality that we deal with, unfortunately, right now. Justice Sotomayor, in her dissent, chides the majority for failing to engage with congressional intent. And so, what was the congressional intent of our asylum law and processes, Mary?
It's pretty complicated, but the original intent was in 1980, the Refugee Act included asylum, and it was sort of the counterpart to admitting refugees. People in the country were able to seek asylum if they feared persecution based on protected grounds like race, nationality, political opinion, so on, religion. And it was fairly clear. It said anybody in the United States or seeking, I think it said seeking entry at the beginning. I can't quite remember. But then in 1996, when Congress adopted the expedited removal laws that are a truncated version of inspection and entry and can deport someone without letting them go through a full judicial review, Congress did make sure to include sort of a safeguard for people seeking asylum. And a lot of people have probably heard of credible fear and that process. And that was actually, part of the things that back in 96, 97, people like me were working on to try to create a process that really allowed people to have the room they needed to be able to set out a claim. And it's that intersection of all those laws where the words to describe what someone was doing, they were arriving in now, because we didn't have a separate sort of adjudication for people in the country and people who were trying to get into the country. It was all put into one, called the removal proceeding. There was an effort to like make all the words join up, make sense. And it's a little sticky. I mean, there are lots and lots of places where it says arriving in or at or on or whatever. But the point is, when you step back and you look at all of it, it is pretty clear that Congress still intends for someone to be able to have that opportunity, both under the Refugee Act, but also under our international obligations, where no country is supposed to turn away someone who is directly seeking their assistance if they're fleeing persecution.
And I feel like what we're seeing, both from the administration and partially from the Supreme Court in these decisions, is this ignoring, right, of this historical context and the facts that are happening. We saw it also in '96 with the unlawful presence, the creation of the unlawful presence bar, where now folks stayed. The building of the wall, which leads people to stay instead of the migration that used to go
Right.
back and forth. And it's using the administration also, who keeps on getting rid of people in the government, like Mary, like other folks who have been in government, who come with that context and that knowledge to make sure that policy that's being implemented is being implemented with a particular goal, trying to implement that congressional intent, that historical context into it. And instead, they have a very clear end that they're going for. And our time is running out. If there's anything either of you want to add as a final parting point on Mullen versus Otro Lado, if not, I will do our final house cleaning.
Just don't give up on asylum. Keep helping people try to get protection. There are still other mechanisms out there. The road is harder, but between fighting the individual cases, and I think probably having to work on legislation that clarifies and simplifies the language, we can come back from this. But it's a pretty sad state of the world to be in right now, and we really just have to fight really hard to preserve that right to seek freedom from persecution.
I don't have
Kevin,
I don't have anything to add other than yes, keep fighting. And as far as immigration is concerned, there have been darker days, and we always do seem to come out on the other side. So we're definitely in a dark place right now, but I'm sure you could have pinpointed some place 80 years ago, 60 years ago, and if you had heard what's happening today with immigration or race relations, you'd say, "Wow, that's pretty good." So maybe a larger um a larger spectrum of thinking. That helps me at least because we're definitely in a fight right now that is civil rights advocates and immigration advocates.
take solace in the fact that we're on the right side. Thank you again, both Kevin and Mary, for shedding light on what is happening here and how it's impacting our immigrant communities, particularly our asylum seekers, and the difficulties that will be faced. To everyone who joined us today, thank you for being a part of this important dialogue. The issues we've explored are complex and challenging, but by coming together in spaces like this, we're taking meaningful steps towards progress. Remember, the work does not stop here. It continues with the action we take in our communities, our workplaces, and within the UK. I encourage you to stay engaged with the Commission on Immigration. Follow us on social media to learn more about the work and how you can support it. You can also engage with the ABA Civil Rights and Social Justice section and become a member if you aren't one already. Visit our website, explore upcoming events, and consider joining one of the committees to help shape the work we're doing. You can do so at ambar.org/CRSJ. Once again, thank you for watching. Thank you, Kevin and Mary. Keep up the fight, and together we can make a difference. Thank you, everyone.
Thank you,
Thank you.
Homero.
Thank
Thank you,
you,
Mary.
Amira.
Thank you,
Thank
ABA.